another hearing for her. She is charged in the death of her boyfriend, who investigators say she zipped him up in a suitcase and left him to die. She is now with a new attorney after representing herself for a short time, and that followed after going through 8 court-appointed attorneys. So the trial is scheduled for October, but the defense is asking to push that back for several reasons. And here with us now to talk about this case is Jose Rivas. He's a criminal defense attorney, not affiliated with this case, but helping give us some insight into what Boone's team is now dealing with. And Jose, thanks so much for joining us here on Fox 35 News Plus.
Thank you. Pleasure to be here.
So I'm curious, Jose, if you were the attorney who is now hired on to take over this case, this is very late in the ball game, I would imagine, to take over a case like this.
Yes, in this particular case, obviously has severe penalties where this individual could go to prison for a very long time. So when we come in on a case like this, we usually don't like to come in, but when we come in, we have to understand that we're taking the case as it comes. So whatever work was done or was not done in the past by the previous 7 attorneys, we have to fix that problem. What we don't get to do, we don't get to go back and question new witnesses or question witnesses that have already been questioned. We can't go back. We try to fix what was done in the past, and we can explore new defenses, but we don't get to reset the clock. We have to be ready once we get on the case. We're telling the court that we're ready to take this case for trial. We have all the knowledge, all the witnesses, and we've reviewed all the evidence. In this particular case, they're asking for a continuance because it's a very short time for this case to go to trial, and you obviously need a lot more time to get ready.
And we do know, as I mentioned in the setup there, that Sarah Boone has gone through 8 other attorneys. So how would an attorney prepare to step into a case like this?
Well, when they first hire you, come in, you talk to the client. Later, the expectations could change. And what happens is that sometimes defendants, they don't like what they listen. They don't like what the attorney is telling them. So if it becomes to a level of lack of communication, for example, or something like sometimes defendants want you to file a motion that has no legal basis whatsoever. As attorneys, we have an ethics to the Florida bar, to our license to follow the law and represent our clients. So we can't just file a motion just because our client is asking us to file a motion if there's no legal basis. So sometimes you come into what we call irreconcilable consequences, where there's no communication. We can't agree on a defense. We can't move forward. And for example, sometimes the client will say, I want this to be my only, I want to be your only client. And in the reality, that's impossible. So, there's a lot of different factors. You have to have communication. You have to be able to willing to listen to your client. You have to be able to, to do what he tells you to do, or at least look into investigations, witnesses, and evidence, or people who could exonerate her in the crime. But we can't just go out and just be a puppet of a defendant and just do what they want us to do.
This is a case that has gotten a lot of attention, and no doubt will continue to do so. What difficulties does that present to a defense attorney trying to step in at this late hour and defend their client?
Well, in this case, it's pretty much based on psychological evaluation. When you look at the docket, they've done dozens of evaluations. All of this stuff costs money, which is taxpayers' money, unless they're paying privately. So you'll see there's a lot of motions, over probably a dozen motions, where they're asking the state or the county to pay for this doctor. So we want a mental health evaluation in order to prepare for a defense. The Constitution guarantees the right to a fair trial and a competent trial. So you can't have a competent trial or competent defense if you don't have doctors, psychologists, for example, who's going to interview the defendant and is going to be able to tell the jury the state of mind when this crime occurred. We're not doctors. As lawyers, we're not doctors. The judges are not doctors, and neither is any of the jurors. So in other words, you have to bring experts into the courtroom. Those experts cost money. They take time. And that's why we've been through several attorneys. We keep asking the court to give us funds and more funds for travel expenses, for experts, so that we can prepare an adequate defense. And that's in order to avoid an appeal in the future.
There was a few week span where Sarah Boone was defending herself before, this new attorney, and we did see her in court a couple of times. There were a few hearings where she acted on her own behalf, and it was clear. In fact, she said this in a number of those hearings: "I don't know what I'm doing," telling the judge, I don't know what I'm doing. I don't know the proper procedure. Do you think this is better for everyone now that she does have an attorney, as opposed to her having to defend herself in the upcoming trial?
Absolutely. Again, in the courtroom, what we want to do is, as defense attorneys, we want to preserve their right to be able to appeal. So if a judge makes a bad decision, we can appeal a conviction. Now, on the other hand, if the judge allows this defendant to move forward and represent herself, and she misses key witnesses, she doesn't know what she's doing literally, and there's a conviction, she can come back later and say, hey, the judge knew that I didn't know what I was doing, and the judge let me continue to try and represent myself. The judge should not let me continue to represent myself. So what we want to avoid is appeals. We want to avoid any kind of errors in decisions. We want to be able to, all the evidence that's going to be admitted into court, we want the evidence to be legal. And again, it all boils down to, we want her to have proper representation and competent representation. And she's not competent enough in the field of law to represent herself.
Because as you talked about, the defense attorney's kind of top job right now is trying to figure out how to make sure that this is a fair trial for Sarah Boone.
Of course, he's going to go back, and now it's going to have to start from scratch. There's been possibly dozens of depositions, which are interviews under oath of all the witnesses, all the detective, forensic experts, and evaluation. He has to go back and review all of those, all the transcripts which come from the depositions, which again, they've asked the court to supply for cost of those transcripts. He has to bring himself up to date on all that information, because when he sits there and he says, I'm ready to go to trial, the court is going to assume that he's read every single word and he's totally familiar with this case 100%. He can't come in and say later, well, I didn't sit in, I didn't represent her during that time frame. He's responsible, the attorney's responsible to know everything about this case and be prepared to go to trial once he says that he's ready for trial. Because if he goes to trial and he's not prepared, again, there will be an appeal later on, and the defendant will claim that he had inefficient counsel, and therefore there will be an appeal, and the whole case gets reopened again. It
sounds like a lot of homework ahead for that legal team. Jose Rivas, criminal defense attorney, thank you so much for joining us on Fox 35 News Plus.